Guys, this hearing starts with confusion that instantly turns serious as the judge realizes required filings are missing. What sounds like a simple clerical issue quickly exposes deeper credibility problems, setting a tense tone where every word matters and no excuse lands the way it should.
This is really odd. I filed them. I packed the baby up in the baby carrier and everything, and with my 4-year-old, we filed them.
So there's nothing new in Odyssey unless maybe she filed it this morning,
I put my whole entire life.
or if there were issues and it got rejected, but they would have called her.
Yeah, and I followed a parenting plan too, which is odd. I did everything that I was supposed to.
Well, I want to remind you, you did
I'm
everything
shaking
you were
right now.
supposed to 2 months later than you were supposed to, but
I know, I'm sorry. I do apologize with that. I was behind.
well, that's part of the problem, Miss Erickson. I understand again how difficult this process is for somebody that's not represented. But we had a trial on this matter on the 26th of October. I gave you almost 2 months to get everything filed, and there's still absolutely nothing in the file. Absolutely nothing. And that doesn't work for me. I don't know how much more.
May I say something?
I'm talking, and when you keep interrupting me, I can't tell you how frustrating that is. I've had that conversation with you so many times. I don't interrupt you. Please don't interrupt me. Okay. I can't tell you how difficult it is understanding the difficulties of navigating this the judicial system for this case. I don't know how much more accommodating the court can be, frankly. We had a trial. I could have made a ruling that very day, and I gave you an opportunity to provide information to the court. And I'm here 2 months later, and I have nothing. And I have information that Miss Winkles filed where she was trying to help you file this information and show you how to do that. It's email exchanges, you and back and forth that she's filed with me, telling you exactly what you need to do, and I still have nothing. So I am happy to hear from you. Please let me know why you have done nothing.
Well, if her drug tests are all clean and it's not showing that she's taking Suboxone, but she is taking Suboxone, or she's saying she's taking Suboxone, that's a clear indicator to me as a recovering addict myself that she's using stuff she's not supposed to be using, and she's doing something to tamper with the hair follicle or whatever it is they're testing.
I have done everything. She has taken, okay, I'm confused because when Scott Roberts was a part of when he was my attorney, he told me that she had taken out everything that I had put into the courts because of some kind of it was when I was at the doctor's or whatever. And supposedly something happened and we weren't supposed to be able to tell you about it, about his criminal history, about the DV. Apparently I wasn't supposed to speak of any of it. That's what Scott Roberts told me. So I had to sit there quietly about that
report and the parenting plan and any of that.
And then with that, Scott Roberts, I gave him everything. I seen him on here earlier and it kind of irritated me. I gave him everything to turn in. He said he turned it in. He even gave me a declaration that he wrote out, and he said he turned it in. Nothing had been turned in, and I'm just now finding that out. And I apologize. I can get everything else back in. If I can be given at least a few days, I can't. I've raised my child on my own. This is just crazy to me. Erin wants to come into her life when she's 3.5 years old. That's fine. That's fine. But please don't take her from me. I've been trying to do everything I can. I did a parenting plan on my own. I did the law help one where they helped me do it, step by step. I thought that was pretty cool because I didn't know that they did that. Requesting for him to have first, third weekends of the month and every other Wednesday. I just don't understand how none of them are in there. I have turned them in. I put my entire life on that. I'm really, really baffled and kind of confused, and I don't understand any of this. It's a bad dream.
And Your Honor, if I might, even if she turned those in, they're still not compliant. as I told her, that's from May of this year. It was not collateralized. None of it's collateralized.
It was
Your Honor
collateralized.
said
Sorry.
I have that in my office. I can send it to the court and the parties. It was not collateralized. My client was never
May I speak?
contacted. Miss Langford was never contacted, which is why she got the other email saying, you need to call. This is not collateralized. The court is very clear. It needs to be updated. So I'm not
No.
sure where to go. We were more than willing to try to do everything we could, but if we don't have the information, I'm not sure where to go from here. So I'd leave it in Your Honor's hands.
All right, Miss Erickson, now you can talk. Please let people speak and
sorry, I
then
don't-
speak. Go ahead.
I'm sorry. It's just it angers me because that's not true. So when I went to Columbia Wellness to get the paperwork for you, what was it, a few weeks ago, to get my assessments, because she said they weren't assessments, they were what did she say they were? Intakes. But they clearly state assessment and they were highlighted there. The lady highlighted it for her. And then that's the reason why it took a little bit longer to get to you, because, well, it should be in there anyways, because I had to go all the way back to Columbia Wellness because the Superior Court wouldn't take it with the highlighter on it. And I didn't know that. And I was speaking with the lady and I was just basically rambling like I am now and venting because I have nobody else to vent to about the situation. And she goes, well, that's funny because I had spoke to Mr. Anderson on the phone about this. He continuously tried to push that they are to contact him for collateral. And numerous times has he been told, and so has his attorney. My counselor even told his attorney. He told me this, that no, you are to call. The ROIs have been signed since beginning, have been signed. They've been done. All they needed to do was call. That was my fault for not telling them Columbia Wellness, because I initially at the time thought they knew it, because that's what Vashti told me was Columbia Wellness is where you get it done. I just had the baby, so I was kind of going through a lot, and then plus having threats of my baby being taken from me when I raised her on my own.
Pay close attention as the judge's patience clearly wears thin and the courtroom energy shifts. What began as explanations now feels like repeated avoidance, and you can sense the moment where understanding turns into accountability, changing how the court views everything that follows.
Anyways, and I was like, really? And then she continued to say that she actually had to send him to one of the bigger bosses, and I think his name's Chris or something like that. And Aaron continuously argued, trying to make that man say that no, we're to contact you. You're right. And he said, no, they told him that, the ROI has been done. You contact, and they've contact. I was told by that lady, and it showed in my account, supposedly that's what she said, was that they have already contacted over my assessments and stuff. So that's why I'm getting upset, because I'm extremely, extremely concerned on why people are lying so much. Like, I don't understand it. I have to be honest. And then receiving something about my child's doctor when I had already in the beginning, even Vashti knows that she goes not to child and adolescent. Like, where did that come from? Like, all this stuff that they're throwing at me when there's not supposed to be abusive litigation, that's said on my protection order. It is stated by Mary Hahn, because that's exactly what he does. And that's why I'm upset. I'm trying to calm down. I'm sorry. This is what Aaron does. It's just like, it's been one thing after another after another. I've done what I was supposed to do. I thought Scott Roberts did what he was supposed to do. He took $5,000 from us, and we worked hard for that. I don't have that. I can't afford that for another attorney to show that I'm being honest. So I'm trying to use my voice, and it's so hard to do this right now. But everything that has came out from Miss Winkle and Mr. Anderson is just completely baffling. It's not even true. Like I don't even understand it. Like, why? My child goes to Vancouver Clinic. She has since I gave birth to her, you know, like.
Okay,
I'm so sorry.
couple different, I thank you, Miss Erickson. I understand your frustration. The clerk asked of, she's in the courtroom, she asked of the folks in the office if there was paperwork filed. They indicated that there was paperwork filed, but they weren't, or brought in. They were not filed because they all have the wrong cause number on them. So I asked if they could be brought to me, and that's what I just received. I obviously have not reviewed them. They all have the incorrect cause number on them, the parenting plan, and it looks like some healthcare records. Is that what you received, Ms. Winkles?
It is, Your Honor. And just so you're aware, Miss Langford has her hand up. I'm not sure if you can see that.
No, I did not see that. Ms. Langford, if you want to jump in here, by all means, go ahead and make your comment.
Yes, I'm sorry. I don't have camera ability. I'm at OHSU, where I've been pretty much every day since Thanksgiving. So I just want to clarify some things. I've never, ever received confirmation that I am on RRI for Columbia Wellness, as it states in my report. I've called, and they keep telling me the same thing, that I am not on the RRI. I've reminded Miss Erickson I need to be on there for collateral. I've not received any documentation from her since way prior to the hearing or to the trial. I still have not been contacted for any additional assessment since the one we've seen in May. Her attorney actually asked me for documentations and said he had nothing from her prior to him removing himself from the case. I gave him what I had. And I'm honestly probably equally frustrated because I've given reminders that this needs to happen, this needs to be done prior to the trial. And honestly, I have medical things with my family to deal with, and having to be dragged back and forth because we're still not getting what we need is very frustrating for me. Because I want what's best for the child, and we're not able to do that right now because we're not getting what we need. And I've not received anything from Mrs. Erickson since way prior to the actual trial that we had.
And I appreciate that, Ms. Langford. Can I just ask a follow-up question? I know that you were present at the trial that we held back in October of this year, and at that point made recommendations. Is anything about the recommendations you made at trial back in October, has anything changed, I guess?
No, I think that I at this point I would agree with anything that you're recommending, because we're just not getting what we need to verify any information, and we're all coming back to the same courtroom for the same responses, and we can't say what's best for a child. We don't have all the information, which is what we're not getting.
All right, I appreciate that. Thank you. Okay.
May I say something? I can pull it up on my phone even. Vashti's been in there since I did it all at the same time. Why wouldn't I? I did.
Emotions overflow here as frustration, stress, and personal hardship collide in real time. Instead of clearing the air, each explanation adds another layer of uncertainty, leaving viewers to question whether this is confusion, miscommunication, or a pattern that keeps repeating.
And I told her, I even have an email from Vashti that said, I was like, what else do I need? And she said she had everything from me. I have that in an email. I can, if I could send it over to you right now, I would. And I should have printed it out. I had a feeling to print it out, but I've been having to use my boyfriend's work at because he's a mechanic and we don't have a printer in the apartment. So I've been trying to, you know, find out ways of getting you those documents. I swear I have put all my ROIs in. That was my major deal. Like, that's a huge deal. Why wouldn't I? Like, that's my baby. I don't understand what's going on. It's like a really bad dream right now. Like, really, really, really bad. Because if I could get you everything, I'll give you all my whole profile. It shows exactly the dates when I put those ROIs in. It shows the dates and the times. And they have been in there since way before May. And I'm sorry to overtalk. That's why I needed an attorney, because I don't understand a lot of this stuff. But I need them for my boys, because I'm not good at what I'm sorry, my 11-year-old's bugging me. Lexi, go sit down, please.
All right. Here's where I'm at. I kind of echo Miss Langford's comments, because I feel like even though we went through a trial, there wasn't a lot of information at the time. Mr. Anderson hadn't even, I don't believe, started any kind of weekend visitations. And I believe that we were progressing towards those with the help of Miss Rosen and her working with the child here. And but at some point I feel, I do agree with Miss Erickson that this is kind of like a bad dream, because I feel like it's the same issues repeatedly over and over again. I'm reviewing my notes and I'm reviewing the minutes from the trial, and very specifically, there was a discussion with Miss Erickson that she needed to sign ROIs because those had not been done, and that the mental health evaluation that was done prior this year would not be appropriate because it was already at that point over 5 months old, and a new evaluation would need to be done that was collateralized. We've done nothing. So we haven't even been able to do that.
I'm gonna be complete. Sorry. I'm gonna be honest.
I'm gonna talk. So I don't know if Miss Erickson just chose to zone out when the court was making the rulings back in October.
I didn't hear
But
it.
all of the, I'm muting you because you keep interrupting me. So please don't unmute unless it's your turn to speak. Very, very clearly in my notes, in the minutes, it was discussed that release of information need to be signed for all the parties so they can all be contacted for input. And it sounds like the only thing that she's done is the hair follicle, which is great. And I'm glad that that came back clean. I agree with Ms. Winkles. There is some concerns if she's claiming she's on a Suboxone program and it's not even showing that. That is a concern. That doesn't just, I get immune to a Suboxone, so it's not in my hair. That's not how that works. She did inquire of the court whether she could file a proposed parenting plan. I said, well, you can always file a proposed parenting plan. So now I just now received that after asking the clerks to have it brought back to me, even though it's under the completely wrong cause number. So I feel like I'm extremely frustrated. I don't want to suggest at this point that Miss Erickson is a bad person, a bad mother, but I do find that there's some definite concerns about what her cooperation level would be like on any kind of parenting plan with Mr. Anderson. She claims that she wants Mr. Anderson to have visitation and to do all that. But I'm just concerned whether how that would go. Her proposed parenting plan, and Ms. Winkles, you indicated that you did have this copy, so that's why I'm referring to it. Basically says that he has to comply with treatment and that he would get the first and third weekends of the month And that's school age and non-school age. And that's pretty much it. Your proposed parenting plan.
I meant to put Wednesdays on there. I redid another one and it deleted completely. I'm sorry.
Your proposed parenting plan basically has, I mean, it's the extreme in the other direction that,
It is a phased in approach. It's an extreme until she gets the collateral mental health. And I believe it moves to more of what Your Honor was talking about in the trial, the 50-50, but without that collateralized mental health, we had it the extreme. We had 2 actually filed.
we've had weekends with Dad.
Yes, he's had overnights. I believe he just had the last weekend.
I did have my overnight this last Saturday.
All right, so, I do recall, we just have layers. I understand Miss Erickson probably is a, stressed out, single parent. I know that this is not her only child. I know there's a lot going on, and this.
This is where things quietly but powerfully change as outside voices step in. The guardian's calm confirmation cuts through the emotion, reinforcing the court's concerns and shifting the case from debate to verification, making it clear this isn't just one person's opinion.
It's hard to prioritize things, but obviously this was a pretty major situation. I have proposed orders that Ms. Winkles has provided. What I'd like to have happen is so I'm gonna adopt the orders. There's one thing I'm gonna take out the 191 of substance abuse as it relates to Miss Erickson in the proposed parenting plan. She's a clean hair follicle. There was a history, but her claim is that she's been clean for I believe she said 6 years. So great. I'm gonna take that out of the mix here. So I'm gonna sign this parenting plan. So what that means, Miss Erickson, is you're gonna have visitation with your child until you get that that evaluation done. And then once that evaluation is done and it's collateralized, then my hope is that we'll move to a 50-50 parenting plan. But you have to get that evaluation done. It has to be collateralized. That includes Miss Langford, Miss Winkles, Mr. Anderson. Those people have to have that information. Once that information is provided to the court, then we'll have another hearing and adjust the parenting plan based on that. Is there a visitation that was scheduled for this weekend? Or when was it? Was there another visit?
We were going by Charlotte. We were going by Charlotte.
Mr. Anderson, was there one for this weekend?
We were waiting for what the court hearing was going, and Charlotte wanted me to contact her after the
All Ellie knows is
propose everything.
you're hurting my child.
I hope I'm not hurting your child, ma'am, but I can't.
No, not you. I wasn't talking about you. I was because he was speaking, and I'm just saying that because he never tried until I got pregnant. So it's like I raised my baby on my own.
I'm not suggesting that you haven't put the work in, but there's concerns here that have been raised by multiple individuals.
I really didn't hear the
going on. There was
I had the baby and I was going through. Okay. I went through postpartum.
I'm done at this point. I can't argue over the top of you. I've made it known in several court dates what's been requested of you. I've tried to give you ample opportunities to get that done. I, again, am not in any way indicating that you're a bad person or a bad mother, but there are things that the courts ordered that you've basically just ignored. So, we have a healthy relationship that's been established between father and child. And my hope is we'll get to a 50-50 plan, hopefully within the next few months. And this is a temporary situation that we're in. But I'm going to indicate, and there is an indication on here that once that evaluation is done and that there is, you're going to have 60 days to get that evaluation done. That doesn't mean the report has to be done in 60 days. That means it needs to be set up and
It's just
let me rephrase that. Doesn't mean the actual evaluation, like the final report from the provider, needs to be done in 60 days, but the appointment has to be done and made within 60 days.
I'll do it.
And then I'm just going to indicate in here.
Please.
I want to make sure, Ms. Winkles, and please point it out to me if it's in here already, that that this, and I don't know if you want to just set a review date, or that Ms. Erickson can bring it back for reconsideration once that evaluation is done.
I believe it says that she can motion the court the moment it's done, but if I haven't put it in there, that's what I would suggest, just so we don't come back and it's still missing and it looks bad. Maybe as soon as she gets done, if it's done in a week, if it's done in 3 weeks, however long it takes, she can just stick a motion in the court and we can come back. I thought I had it at the end of the evaluation part that she has to do it in 60 days and then she can motion the court. Otherwise it stays the same. But I've done so many parenting plans for this case. I'll be honest with you.
Right.
I can't remember.
It does say, okay, so Ms. Erickson, listen very carefully. It says, after obtaining the relevant evaluation, you can petition the court. And I'm going to say petition the court, and it says to begin weekend visitation. And here's what I'm going to do. I'm going to change the language here. So after obtaining the relevant evaluation, the mother, and this is going to basically be an agreement between Miss Erickson and Miss Winkles. The mother may.
Can I get my custody back?
Can you hold on?
Is there a way to do that?
The mother may begin weekend visitation. So evaluation's done, mother starts weekend visitation. Once the evaluation is done and all the parties have received the report, then mother may petition the court for a change in the parenting plan without an adequate cause finding. So what that means.
The judge lays everything on the table. The court acknowledges stress and struggle, but makes it clear that compliance matters more than intentions, drawing a firm line that reshapes the parenting plan and the road ahead.
Is that once we have the evaluation, everybody's seen the evaluation and been able to weigh in on the evaluation, you come back to court and then we look at the parenting plan and decide what is best moving forward. Once we have that information. Once you've done the evaluation, your weekend visitation would start. Does that make sense? Okay.
So after acknowledging, sorry.
Go ahead and ask the question, Ms. Erickson.
I'm so sorry.
Don't
after I do the collateral, I don't have money for an attorney because that man stole our money. I don't know what to do. I raised her. Like, when can I get her home? That is my baby. It's our baby.
It's
but
exactly,
he just now came into the picture.
I understand that, and that's why we're dealing with it. So I'm not ordering any fees, so I'm striking any judgment as requested, so I'm not taking fees. And I'm gonna mute you again here, and we need to keep our record. See here, there's a child support order in place. Ms. Winkles, I'm gonna table the child support order, and after
That's fine.
60 days, if there's nothing, then I'm gonna enter the child support order. Is that fair?
That's absolutely fine. And Your Honor, just so you're aware, we'd be okay with her filing just a motion rather than a petition. Just because I believe since she's pro se, my client doesn't, he wants to be easy, but he wants to have the information is really where we're at. So we're fine with a motion rather than the full petition, because that might be a little bit more confusing for somebody who's pro se.
Okay.
I don't even understand any of that right now. I'm sorry, I don't. My brain's just.
I understand that, Ms. Erickson. I would remind you, and I'm assuming, Ms. Winkles, you're going to stay on in this case.
I am, Your Honor.
Everything that Ms. Winkles has filed that about your interactions have done nothing but indicate to at least me that she's trying to help both of you through this process. So if you have a question, based on what Ms. Winkles has indicated thus far, I think she would be willing to at least try to answer those questions for you. She can't obviously represent both of you, but I've changed that to may motion the court. So that means you just say, I need to have a hearing in front of the judge about my parenting plan. That's, and you come in and the clerk will help you and you file that. Make sure it's on the right cause number. And so you know that we're under the cause number of 2331508. The child support orders, I am going to set aside. So I'm not ordering any child support at this point. After 60 days, Ms. Erickson, I want you to be very clear. If you don't do anything after 60 days, then this is just going to be the order. Okay.
Yeah, that's not good. That's not possible. And I'm going to make sure that I'll put 3 copies in. And if anybody takes it out, then I don't know what else to say.
I'm glad to hear that. And again, once you get that process started, it sounds like Ms. Winkles will help you ensure that everybody's on there, everybody's doing what they need to do.
I can't trust her. I'm sorry.
Okay, well then do it on your own, I guess.
No, I need help.
I don't know. I can't give you any legal advice. So from sitting on the bench, I can't give you legal advice. There is the Northwest Justice Project. There is Cowlitz County Legal Aid. I don't know where you reside. If you reside outside Cowlitz County, you can contact your local legal aid. But there are services available on Mondays and from 12 starting mid-January, Mondays from noon to 2 p.m. There's a free attorney that's here at the courthouse that you can come and talk to. I'm sorry?
Can I bring my little baby with me?
Of course.
Or is that?
Yes, no, it's not in a courtroom. It's just in the lobby in a room off the lobby of the courthouse. So if you need to bring your children, of course, you can bring your children. We'll get all of this process started. I'm gonna ask that this be filed, your information be filed with a cover sheet with a proper cause number on it. So it shows that you filed something. Okay, Ms. Erickson, because I want to make sure that, you know, you obviously attempted to, but it has the wrong cause number. So I'm going to ask that they file it with the correct cause number on it.
I accidentally put the protection order cause number, and I apologize for that. I didn't realize.
That's okay. I'm going to ask that, I don't know if,
how am I going to see her?
Miss Rosen is probably going to need to, any counseling sessions that we can set up in the next week or two are probably appropriate. I would like the exchange to happen if at all possible. So Miss Erickson would exchange the child with Mr. Anderson on Sunday, the 24th, no later than
there's a protection order. Can my dad do it?
6 p.m. Absolutely. Okay, so I want you to have some time on, and if you want to, if the parties agree to a later time on the 24th, that's fine, but the exchange on the 24th, So mom gets Christmas Eve and then dad will have Christmas Day and then we're going from there. Okay.
Okay.
And Your Honor, I
Sorry,
just want
Ms.
to say, if
Langford.
she needs help with things that I can help with, I'm totally willing to help her. But I can't help with everything, obviously, but I'm willing to help where I can.
I asked you.
Well, Miss Langford's indicating that she's willing to help you. I don't know. I understand you're frustrated and I don't understand you don't like the court's decision, but it's time we need to get this sorted out and you need to follow through with what the court requested of you 2 months ago. So that'll be the order of the court. If it needs to be brought back, any other
No, get out of it.
presentations or if it needs to be before me, that'll have to be Fridays come the new year.
All right. Thank
Final deadlines are set and the message couldn't be clearer. Progress now depends on action, not words. Consequences are spelled out, support is offered, and the future is placed squarely in one person's hands. Like the video, subscribe to the channel, and we'll see you in the next video. Now tell me, do you think the court was fair here? Or should more time have been given?